All right. Hello and a very good afternoon to everyone. Thank you for joining us today. My name is Sheena Verma, Associate Editor at RFMLR and a third year student at RGNUL Punjab. I'll be the host for today's event. I'll briefly tell you about RFMLR and today's panelists before turning it over to Mr. Zamir Nathani, our moderator for the event. He's the Senior Vice President and General Counsel at UFO Movies Limited. Thank you for joining us, sir. RG Annual Financial and Mercantile Law Review is a biannual student-run, double-blind, peer-reviewed law journal based at the Rajiv Gandhi National University of Law, Punjab. Over the years, RFMLR has witnessed participation not only from the student community, but also legal academia and industry professionals. It has been ranked amongst the 10 most viewed law journals in India by SEC Online. RGNUL is an autonomous national law university established in 2006. RGNUL is the only national law university to be accredited by the National Assessment and Accreditation Council with an A grade. We're thrilled to hold this event in collaboration with the Society of Legal Experts and Lex Witness. SCLA is an organization that aims to bring together fraternity members, students of law and commercial disciplines, for sharing their thoughts on commercial laws, policies, and current trends. Lex Witness is India's first magazine on legal and corporate affairs. For over 10 years, since its inception in 2009 as a monthly magazine, Lex Witness has become India's most credible platform for legal luminaries to opine, comment, and share their thoughts. Today, we're going to witness a discussion on e-commerce, its legal issues and regulations. E-commerce as a framework for buying and selling goods and services has successfully penetrated the global market at large, including the Indian market. The associated convenience and accessibility have been instrumental to its rise in India. In this context, it is important to take note of the many allied challenges faced by authorities and consumers alike. These are some of the topics our panelists are going to comment on. We have with us a panel of extremely learned professionals. Let me briefly introduce them to our audience. First, we have with us Mr. Abhishek Malhotra, founder and managing partner at TMT Law Practice. Sir has 2 decades of experience and is a member of both the state bars of California and Delhi. Next up, we have Ms. Akanksha Kaul, advocate at the Supreme Court of India. She has been appearing for the government and various government bodies in high courts and the Supreme Court of India. We're also joined by Mr. Rodney D. Ryder, partner at Scriber Advocates and Legal Consultants. He's also an advisor to the Ministry of Communications and Information Technology on the implementation of the IT Act 2000. Last, but certainly not the least, we have Mr. Aviral Sahai, Principal Associate at Cyril Amarchand Mangaldas. He specializes in white-collar crimes and civil litigation, including arbitrations and dispute advisory. We're honored to have you all here. We also have Professor Dr. Anand Pawar, Vice Chancellor at RGNUL Punjab. Thank you for joining us, sir. I would like to request you to say a few words before we start with the event.
Thank you, Sheena. Good afternoon, one and all. I'm delighted to welcome you all in this expert panel discussion on e-commerce legal issues and regulation, organized collaboratively by the RGNLU Financial and Mercantile Law Review in collaboration with the Society of Corporate Legal Experts and Lex Witness. As we know that the national universities are performing multiple tasks with reference to their academic responsibility. And as per the Act, one of the objectives is to promote the legal research by way of various centers which are there in the university and the multiple different kinds of journals. So one of the very specific journal, RGNLU Financial and Mercantile Law Review, has taken this responsibility. And I congratulate Mr. Akshat Jain and Ayush Goyal and the other associate editors for taking this responsibility. I also welcome Mr. Zamir Nathani, today's moderator, Senior Vice President and the General Counsel, UFO Movies India Limited. We have with us Mr. Ganesh Prasad, the partner e-commerce and private equity Ketan and Company firm. Mr. Abhishek Malhotra, founder and managing partners, TMT Law Practice, Ms. Akansha Kaul, Advocate, Supreme Court of India, Mr. Rodney Ryder, partner, Strike Board Advocates and Legal Consultant, and Mr. Avril Sahai, Principal Associate, Cyril Amarchand and Bangladesh. On behalf of Rajiv Gandhi National University of Law, I welcome all the dignitaries as well as all the participants for a wonderful discussion on e-commerce. As Sheena has already introduced multiple question and aspects which are going to be covered. I am more interested with reference to the recently enacted intermediaries liabilities with reference to e-commerce. So without taking much time and coming in between the expert panel, I welcome you all on behalf of Rajiv Gandhi National University and look forward to have a longer association. And maybe when after the COVID pandemic, I'll invite you all to have some kind of association and activities in the campus itself. Once again, I welcome on behalf of Rajiv Gandhi National University Law. Welcome. Thank you.
Thank you, sir. Before finally turning it over to Mr. Nathani, I would like to inform our audience that Mr. Ganesh Prasad, who was supposed to be here as a panelist, could not join us due to some unavoidable circumstances. And I now request Mr. Nathani to take over from here. All the attendees are requested to direct their questions only to the panelists designated as Q&A and refrain from directly sending questions to our panelists. I once again thank you all from the entire RFMLR board.
All right. So good afternoon, everyone. I have the privilege of having one of the best panelists before me, experts in the field of e-commerce, legal issues and regulations. They've been speaking at most of the time. Ganesh, unfortunately, at 12 o'clock in the night, some family thing came up and he had to excuse himself. But I have the privilege of having Miss Akansha Kaul. She's an advocate, Supreme Court of India, very prominent in the fraternity. Mr. Abhishek Malhotra, he's founder and managing partner of TMT Law Practice, very well known in the field of technology, e-commerce, etc., for a very long time. Aviral has been principal associated with Cyril Amarchand Mangaldas, dealing with this field of e-commerce, technology, media, telecom. Mr. Rodney Ryder, again, a well-known personality. He's also partner with Scribe Board Advocates and Legal Consultant, very well-known in this fraternity. It's a privilege to have this gathering discussing on e-commerce. Just to give you a screenshot of what we are going to discuss, apart from the interpretation of law, cases, judgments, news, the theme of the discussion, to make it very interesting for all of you, is that we will discuss issues of whether e-medicine sale, intellectual property right issues which are coming up, FDI issues which came up, privacy information, personal information and algorithms. So when you go on search to any of the e-commerce website, next time you start getting similar products as a choice to you. Social commerce, expected relaxation in the country while e-commerce business is going, over governance or under governance, domestic protectionism which is there or not there, and is it required to an extent, consumer law, legal metrology, whether the goods which you are receiving is a gray market goods, is a counterfeit goods, competition law issues have come up, cyber frauds are happening, and whether the regulations presently are adequate enough to address those issues, whether there are adequate compliances which are available to us, to the industry, whether there are adequate redressal mechanisms which are there in case something in the industry goes wrong, and whether a special law or regulation is required as the e-commerce world becomes more bigger, more influential for the consumer, for the competition, in terms of market share, foreign investments, and the economy. All right, so that's the theme of it. And we are going to give you every bits and pieces of it, including the intermediary information which was requested. Just to give you a broad theme about the discussion, after giving the snapshot of it, There are two types of e-commerce business model. All right, just to give the glimpse to the audience that what are we going to discuss and give you a briefing about it. Number one is the marketplace model, and number two is inventory model. So in marketplace model, e-commerce is not allowed to have a direct investment. So what they actually do is that they create a selling arm, which is a marketplace model, where they try to show there is no connection between them, but behind the veil, they are connected. Most of the marketplaces are actually violating this bracket on limited investment inventories by creating a way out. In other words, it can be said that they've identified the loopholes and are using it to their advantage. For instance, if you see the MCI press note of 2018, review of policy on FDI in e-commerce, provides that e-commerce entity providing marketplace will not exercise ownership or control over the inventory, that is the goods which is purportedly sold to the consumer. Meaning thereby in marketplace model e-commerce business like Amazon, Flipkart, Myntra, etc., they cannot have FDI mode in certain person. FDI is not allowed in B2C, which is business to consumer, but only in B2B, business to business. All right. Your Future Group and Amazon is a business to business model. All right. I'll be giving you a lot of names because you are hearing it in the news. It's a very hot topic which is going on. What these market models basically are trying to do is that stocking them in their inventories and then selling it to the customers, thereby themselves creating a business to consumer model. All right. So today you also have Amazon suitcases and other products which are available. They further went ahead and mentioned if sellers are selling more than 25% of a particular vendor directly or through a group entity, they will be deemed to be holding the inventory of that particular vendor. All right. So Amazon has been selling, has a selling arm called WNS, who used to buy products in bulk and then sell the same to Amazon. So we hope to discuss the efficacy of this press note today, because there's a lot of happening in the front where consumer benefit is seen. On the back end side, there is also a stiff competition which is going. I'll give you a few examples and I'll highlight you why this competition is increasing, because India is a big populated country and has a big market share. All right. Delhi High Court has recently observed in the Amazon and Future deal that Amazon has indirectly gained control over Future retail without government's approval, which is in violation of the foreign direct investment rules under the Foreign Exchange Management Act. Amazon has bought 49% stake in Future Coupons, an unlisted form of Future Group, which is Big Bazaar, with a right to buy a stake in the group's listed entity Future Retail after a few years if the government ended restrictions on foreign ownership of the multi-brand retailer. All right. So front door, back door, there are a lot of activities which are going on. It's a very deliberated, very highlighted subject which we are going to discuss today. Next issue we are going to bring to your notice is about e-pharmacy. All right, you're seeing a lot of ads where Mahendra Singh Dhoni is coming, Nedmats, Practo, MedLife. These are advertisements which you're seeing. There is no regulation in particular that is governing these online pharmacies. All right, there's an ongoing litigation also in Delhi High Court, which my first panelist will also highlight on that. Talking about e-commerce fraud, the threat of data threat, the abuse of privacy top list, Big Basket, one of the most frequently used e-supermarket, was in limelight on the issue of data breach of approximately 20 million users, wherein it was alleged of selling the personal details on dark web. All right. We remember the controversy which happened between Facebook and Cambridge Analytica, which is based in UK, where Facebook was officially contractually selling that data, and that became a big issue. All right. Now, apart from these issues, there are allegations of anti-competitive behavior by e-commerce giants like Amazon, Flipkart. Flipkart is now a Walmart company in the recent past. All right. The Competition Commission of India has also probed into the competition law violation by Amazon and Walmart owned Flipkart over allegations of e-commerce majors promoted and giving discounts to preferred sellers. All right. With these factors in mind, before I go to my first panelist for the questions, recently in e-commerce sector, Amazon and Future dispute came up before Delhi High Court. Amazon has signed a deal with Future wherein the non-compete clause, they have written that they will specifically not sign any contract with any competitor, including Reliance. And therefore, the deal between Reliance and Future has been stayed by Singapore International Arbitration Center in an emergency arbitrator who was appointed. And now it is before the arbitrators for conducting the arbitration in the matter. Yesterday's example, a South Korean company known as Coupang, which is a Amazon of South Korea, it was listed in United States Stock Exchange, and the share went up by 40% on the first day itself before the market fluctuating. Amazon and Reliance are in the market share fray for India in terms of e-commerce. Amazon brought a company known as Whole Foods, which is like a big basket, so that apart from the e-commerce business, it can also get into the food business. Flipkart was acquired by Walmart. The Indian market is so big that Amazon and Reliance both are looking out for a big market share in this. And therefore, the e-commerce portion in terms of the law and regulation becomes such an important discussion, because this will have impact in next 2 years and 5 years, what we discussed today, and what you get as prospective lawyers or lawyers, that this is the trend in e-commerce which is happening. This is what prospectively can be seen from all sides of the coin in terms of the law. All right. With this, I start my first question to Akansha. Akansha, we have the first question on e-pharmacy, where we see the ads of Nedmex, Practo, MedLife. Dhoni is promoting that on the television channels and social media. Just to give you a snapshot before asking you the first question, there was a report by one of the big fours that e-pharmaceutical, e-commerce in pharma business. So today we have Amazon, which is selling all the products. They acquired Whole Foods, which is like a big basket, so it is into food retail. Now the another thing which is opening up is e-pharmacy. The e-pharmacy business in India is expected to be $2.7 billion by 2023. That's the number which is coming up. Looking at those numbers, in the current digital era, there is nothing outside the reach of people. A simple click and the item is delivered at your doorsteps, including pharmaceuticals. There is no regulation in particular governing e-pharmacies, which recently has attracted quite a controversy and attention from judiciary also. Previously, Delhi High Court had passed an order banning sale of medicines through e-pharma, whereas during the lockdown, the government app Arogya Setu linked a number of e-pharmacies for home delivery of medicines, ignoring the order or what may say to be a position. The question of legality and regulations pursuant to the e-pharmacies is not yet a settled position. What are your thoughts and what we should look for in future? Akansha, thank you very much.
Thank you for your question. There is a convenience associated with e-pharmacy or any form of e-commerce. But the problem is that there are certain regulations which a physical pharmacy is subject to. If we are to go forward with e-pharmacies, I'm not against the concept of an e-pharmacy, but then we also need to build the infrastructure to be able to ensure that that the same regulations that are enforced in the case of a physical pharmacy are also applied to e-pharmacy. You can't have them being subjected to different regulations. If there is a prescription drug that if there is a drug which is only a prescription drug, it shouldn't be that you are able to order it online without the requisite prescription and the requisite checks and balances. It's always going to be more expensive to buy a medicine from a physical pharmacist because they have certain fixed costs. Same principles that apply to any e-commerce system. But I also feel that e-pharmacies may not ever be able to completely replace a physical pharmacy. So we should ensure that the physical pharmacies continue and don't become unsustainable. Um, a lot of the medicines that we often require are really cheap. I don't know how far it would be viable or e-pharmacies would be willing to offer those medicines in small quantities. For example, you just need a crocin, you call them up. I don't know how far they'll be willing to send. So, or you need emergency medicines on an emergency basis. At least my experience has been that some of them are not able to deliver immediately. They do take a few hours to deliver. So in that case, you definitely do need a physical pharmacy. So the larger public interest has to, in this case, be balanced with convenience and other such factors. But I don't think right now there is any per se any regulation for e-pharmacies. So
No,
I'm Zamir, sorry, just wanted
Yes.
to chime in here because of the
Yes,
fact I know
please.
while this is of course Akanksha's question and she's ably addressed the aspect. Just wanted to bring in one
Yes, please.
perspective on this. And here is where I think in terms of the policy itself and as to how the business, if I can call it that, responds to those policy concerns. The point is in case of an e-pharmacy, as in the case of let's say any other e-commerce portal, there are two ways in which the business can be carried out. One of the aspects which Akanksha addressed was where there is availability of that medicine and which is being delivered by the e-pharmacy itself, in that sense, if I can call it that. The other way of looking at it is e-pharmacy as a platform, as an aggregator of the physical pharmacies themselves. So you place your order on the e-farm on the portal, but it gets delivered by your closest pharmacy. So therefore, you are marrying the convenience of what you would otherwise experience with a nearby pharmacy or a chemist shop, because the timeline is therefore pretty much immediate. And it is to address the situations where there is unavailability or a difficulty of people to go out actually and get that medication, physically to go there and pick it up. So I think whenever that and the policy is being worked on, there are litigations, as you pointed out, Zamir, with regard to this aspect. The reason why I'm highlighting this is because the principle is something which will then be equally applicable to, let's say, an e-diagnostics facility. I want to carry out a test for myself sitting in the confines of my home. I don't want to go to the laboratory to get that test, to give the sample. So similarly, yes, there is the labs are accredited. The process of collection and disposal and reporting is a process that is followed by the law and regulated. No one is saying that they do not need to comply with that. But I think the facilitation of that within the parameters of the law is what is really going to be important. And that's where the standard operating procedures and the self-regulatory environment for these entities is definitely required. Thank you. And sorry, Akanksha, for sort of butting into the
No,
response.
not at all.
I think perfectly, because Abhishek, we are still getting a credit. We spoke last week on OTT and social media, and next week itself, the government came out with some regulations, and we were told that were you giving a precursor to that? Uh, but we still feel that why we are talking on this e-pharmacy is that because there are a lot of issues which are affiliated to it. If counterfeit medicines pop up into the system, I've been seeing this e-commerce business since last 2006 when I was in Reliance, where there was a big investment. And these issues are subsisting, and the government is trying to address, because what happens is that ultimately the matter goes till the Supreme Court, And the government also feels that I don't want a Supreme Court to tell me that it's time to bring a regulation. Why not act upon it when I'm getting so much representation and so much controversies are happening in the court? So, Akansha, one question is that should we look out for a e-commerce regulation when we have e-pharmacy business, or would you like to be sufficient in what has been there today as on date? Like for OTT and social media, you saw the government brought into some regulations because it has to be regulated and governed at some point of time because it was crossing the line. Do you feel it's the right time, or we should still hold on?
No, I think they can be regulated in the sense the existing regulations and rules that are applicable to a physical pharmacy. They just need to be modified maybe a little bit, or rather, I don't even know if they need to be modified, but they can be just implemented better in the case of e-pharmacies. That's it. That's
Okay. All right. Abhishek, going to you, while we are seeing that, this business is predicted to be around $2.7 billion in 2023, which is just 2 years away, and it's a huge thing. Uh, According to the latest policy on FDI in e-commerce, FDI is not permitted in the inventory-based model of e-commerce. And on the other hand, 100% FDI is permitted under automatic rule in marketplace model. Number one, just for another hint to the people who are listening to us, what is an inventory model and what is a market model? Just a one-liner, number one. Number two, what is the reason behind this policy where one policy says FDI is permitted, one policy says FDI is not permitted? And could be the impact of these rules on the e-commerce industry, uh, other stakeholders and India as an FDI destination? Will it hurt that? So number one, just a gist on inventory model and what is market model so that people understand what we are talking. Number two, why the not a word discrimination, but why one is allowed and one is not allowed? And could these rules have an impact on other stakeholders and India in terms of FDI destination or FDI investment in India? Abhishek, thank you.
Sure. I think before I go into okay, let me just first explain the distinction between the two. The marketplace model is where there is a pure aggregation. The example that I just gave, you're only a platform where multiple people are just coming and registering themselves and making their goods or services available. And the marketplace itself, the e-commerce platform, is not controlling any shares or any control in terms of management in any or more one or more of those entities, nor does it actually own the inventory that those people are supposed to be putting out as being available for purchase. In the case of an inventory model, as a corollary, the marketplace or the e-commerce platform is actually owning the inventory. They have that available with them. Just to again give the example of what Akanksha was talking about, where the, let's say, so-called e-pharmacy actually owns those inventories of medicines and then gets them delivered. That's the inventory model, and that's the distinction between the two. It has also been held that if I am controlling more than 25% of the sales of one particular vendor or retailer, then I would qualify under this issue of an inventory model. So those are the broad distinctions between the two. Now, as to why is it that there is permission for marketplace model to have FDI and there is an issue with regard to the inventory model? I think the fundamental proposition is a matter of policy, first of all. And that's been a consistent policy that's been around for a while now. It's not new, which is, and if I can use that term, protection for the smaller retailers. Yeah, your in the brick and mortar world, your kirana stores and the neighborhood stores, which need that when we go and buy something from a local store, there is of course an MRP on that, and we are typically sold that product at that MRP. But the kirana store, however, would get a margin from the wholesaler and be able to make some money in that. What is happening, or what is the possibility of happening, and which is what the government potentially wishes to protect these people against, is the practice of the e-commerce marketplaces to be able to mark down those prices even below the MRP to such an extent that it becomes difficult for your local kirana store or the smaller retail players to be able to effectively compete. And with the FDI comes the ability to be able to offer those at greater amount of discount and aggregate greater number of customers, clients to yourself, rather at the cost of incurring losses in the short or medium term, and then be able to give more products and cover up those losses in some way or the other. And sometimes even losses don't matter, it's just a question of valuation, as we've all seen, right? So it's that protectionism, paternalistic model that is sought to be followed to protect such interests. That's the reason why there is a distinction that has been made as a matter of policy between what is permissible at the marketplace model and what is not going to be permitted in the inventory model. One way possibly, and it's not really a huge alternative, but if you are looking at a single brand retail trading option, where under one brand only you are seeking to sell, then that you are permissible in the foreign direct investment is permitted to that. If you already have an existing brick and mortar shop for which you are only translating that additionally as an e-commerce option for a single brand retail, that's not a problem. You can do so. If you've not set it up yet and you commit to do that within 2 years and you actually do that within 2 years, you are also permitted to do that. The important part is the single brand retail is it has to be a single originating from a single brand, and that branding has to take place at the time of manufacture. So that loophole is plugged with regard to when that branding needs to be also taking place. So, and of course, if it is wholesale trading, then it's FDI is permitted. So there are these caveats that have been given, but otherwise the broad policy is this. What would be the impact of this? I think from a point of view of India as a foreign direct investment destination, and whether this is something which is going to hurt us or not, just statistically, whereas we have a huge internet penetration and massive mobile usage in the country, nevertheless, the total amount of contribution of e-commerce retail to the overall picture of retail is only 3% or a whereabouts, thereabouts. So clearly, if there is greater amount of FDI, that could be pushed. But I think that's a gradual process, which perhaps we will come to in terms of more as a policy decision. I don't think that if there is such a policy and we are tweaking that policy further to permit foreign direct investment and allow for that through single brand retail and for local procurement, then we are somewhere balancing the two aspects.
Right. I think well said. So I think the market model and the inventory model is basically worked out to balance between the Indian business as well as the foreign business, which is kicking in, as well as the single entity protection, which is already there. And of course, in wholesale, where you have metro cash and carry, etc., those type of business were already secured. Metro cash and carry is originated in Germany and has been in India for a very long time. So one question which Akansha had addressed was about e-pharmacy. You have addressed on foreign direct investment and how the government has come out with a model which will be protecting as well as in kind of domestic protectionism to the Indian businesses as well as foreign direct investment. So it's a bridge and balance between the two. Single brand was the thought process which was already effective with the government, and of course wholesale jurisdiction was always allowed because that's beneficial to the trade. Going on from e-pharmacy FDI to now the consumers who go to the websites or the apps of e-commerce companies like Amazon, Flipkart, eBay, etc. Of the world. The first thing what you see when you're evaluating a product is the reviews which are given. This product is wonderful, this is a great product, it's given me a lot of benefit, etc. Some of the reviews were also fake reviews, and that issue also came up under the competition law My next question is to Mr. Aviral Sai, Principal Associate Cyril Amarchand Mangaldas. Government did the right thing by promulgating a law or the rules known as Consumer Protection E-commerce Rules 2020 in July of 2020, which brought about a paradigm shift in a decade-old consumer law in India, with implications ranging from punishment of fake reviews to competition law issues and integration with the Information Technology Act. Uh, how do you see the rules playing out from a dispute or investigation perspective at the moment? Avril, thank you.
Thank you, Zamir. That's a very interesting question. There are a few parts to this. I think looking at this from a consumer's perspective, an e-commerce platform or a marketplace is akin to what in a brick and mortar would be a mall. So a DLF has 50 shops. You go to the shop, each individual shop, and buy whatever you're buying. Similarly, on an Amazon or a Flipkart, you would buy from a seller. Amazon is just providing us that technological mall now. However, which is why till now, I think at least the consumer protection law in India was not recognizing that there may be perhaps a difference in what an Amazon does against what a DLF does when it builds a mall. The reason for that is that a consumer relies heavily upon the marketplace that is provided to them to verify the product that they are going to purchase. And for this, the Consumer Protection Act in 2019 and the rules that came in thereafter, I think provide a big shift in how a consumer can approach any issue that they may face while purchasing a good or a service. Prime in this is understanding the concept of unfair trade practices when it comes to online or e-commerce marketplaces. Again, ancillary is fake reviews or even what are the responsibilities of these marketplaces. Just a brief background here, after the MRTP was repealed in favor of the Consumer Protection Act, there was a lacuna in the law where a consumer either had the opportunity of going to the CCI for unfair trade practices, where there are many cases where the CCI has just put their hands up and said, sorry, not our problem, while they've attempted to be a little sympathetic, but they've simply said, no, not our problem. Or go to a regular consumer court where the consumer court would again put their hands up and say, take it up with the seller. The e-commerce platform has no concern or no involvement here. But now the rules, very interestingly, have brought in clear responsibilities and obligations on e-commerce entities, distinguished an inventory-based e-commerce entity, a marketplace e-commerce entity, imposed an obligation on these entities to ensure, just on the inventory e-commerce and on a seller on such an e-commerce marketplace, an obligation to ensure that fake reviews or misleading reports are not put up as regards a particular good or a service that is being offered. So the paradigm shift is going towards holding people responsible when they are in charge or in control of the information that reaches the consumer. And they've linked this with the Information Technology Act and the responsibility of an intermediary, who in this case is that e-commerce entity, to conduct a due diligence on the seller, to conduct due diligence on the product market and to the relevant geographical market as well, which I think is a great initiative. This does tie in, however, with the National E-commerce Policy of 2019, though the government, the Industry and Internal Trade Department did put up a draft of this policy, which is extremely comprehensive, I must say, talking about anti-counterfeiting, anti-fraud, cyber crimes. But this policy is yet not implemented. It's, I understand, put on hold because of COVID. But hopefully we see a little more clarity in regulations, because while the e-commerce rules are extremely helpful, it does beg a few questions of, say, extraterritorial application. What if a foreigner is facilitating the sale of goods in India? Can Indian law even penalize him for any uh, misaction or misleading advertisement, so on and so forth? So those aspects I do believe can come up before a court of law, but it's definitely a step in the right direction for regulation of this industry from a consumer's perspective.
Wow, Wonderful, I think, because today when the companies are made responsible to see that if there is a fake review which is coming up, if the company which is selling the goods is not subject to a due diligence, then I think it will be an open market. Forget the counterfeit part of it. Uh, it will be enormous gray market which will be parallelly existing, and somebody must be using a brand. Now, e-pharmacy, FDI, and consumer protection, how now consumer has been protected under the e-commerce rules on the consumer law, which has been brought by the government in 2020, where even fake reviews, or if the company which is selling goods on the e-commerce platform like Amazon, Flipkart, etc., is also subject to, if there is wrong information which is there, has benefited the consumer a lot. But seeing the other side of the coin, where the companies themselves are involved, uh, what's the kind of my next question is to Rodney. When we see from a company perspective, when I was in Stanford University for US IP laws, we had example of Louis Vuitton hotel in one of the South Asian countries with a similar mark, and of course then there was a stay and all which had happened. Uh, it's a deep impact to the brands which is existing. The companies which are now also selling the brands like Louis Vuitton is there, or you may have any Indian brands which is selling out in the market. Online brand management and consumer protection point of view, what can the brand owners do or protect themselves from issues such as trademark infringement or counterfeit goods on e-commerce store? Rodney, question is to you. Number one. Number two, cyber fraud, impersonation, online brand abuse, etc. There has been a surge in cyber fraud through impersonation of corporate identities and or brand names, especially during the past years. In many cases, brand identity of e-commerce store is being misused to defraud the general public by offering free, surprisingly low prices of product. What can be done by the affected companies and general public to protect and prevent themselves against the fraudulent activity? So one is the trademark infringement and counterfeit goods issue which the companies face, and what are your thoughts on the cyber crimes which are happening? Rodney, thank you.
Right. Thank you, Zamir. Thank you so much. And before I answer your questions, a very big thank you to RGNUL, to Lex Witness. Thank you for having me here. And years ago, it was an absolute delight visiting your beautiful campus in Patiala. And I wish this session was there. Not only to be at your campus, but to interact with all you wonderful people face to face, and perhaps shake your hand as well. Uh, I'll start with the limits to online brand protection, because many years ago I heard of this bright person who, in order to publish himself as Jeffrey Archer, went and changed his name to Jeffrey Archer, with a proper affidavit and the likes. So, of course, there's no limit to what people can do. But jokes apart, coming to the system as we understand it, it starts with the domain name, and it starts with security around that domain name. And we must all remember that the domain name system was not built for security. The DNS architecture was built when the internet was much smaller and connectivity was the concern, and security was definitely not the primary consideration. So as a result, when a resolver sends a query to the authoritative domain name server, the resolver has no way to identify the authenticity of the response. That means if there's any cached data, we don't know whether that's coming from the original site or not. So one of the key things is to advise corporations on how their primary domain name or their primary web address is to be protected. Then to build in their own customized search, watch, and remove services, monitor marketplaces for unauthorized listings, look at the ownership and owners of the brand to remove those listings. For example, if you work with Unilever directly, you can definitely identify a fake Dove soap, or in our case, we identified a fake Dove perfume for them because of the online parameters. Looking at uh, abusive registration, again, a series of measures have been put in place over the last 2 decades. The EUDRP being one of the most fantastic online dispute resolution systems. During the COVID era, our own .in dispute resolution system, the INDRP, went totally online. That means both the EUDRP and the INDRP now accept only online filings, which is fantastic. Looking at further anti-fraud and uh, uh, monitoring activities, rogue apps, especially during the COVID period, we've seen a number of rogue apps come on both Play Store and the Android iStore. So monitoring and takedown has become almost for many of our clients, for many leading brands, like brushing your teeth. You wake up in the morning and there's a new fake app. It luckily for us, there is a streamlined procedure. Most app stores, the Google Play Store, is responsive, but at the same time there's a lot of work to be done. While we were monitoring infringing domain names, in came compliance with the EU GDPR. So privacy was redacted on many domain names. But then again, there are ways to find out whether the domain name is a genuine one belonging to the brand, or whether it is engaged in counterfeit activities, or even owned by illegal entities. Because many of these domain names have no websites, are not listed for sale, but their email addresses linked to the domain name may be used for nefarious purposes, like we discovered for Schlumberger, General Motors, and the others. So this is becoming a big area, because many traditional businesses are moving now partly or completely online. Much of the workforce, which earlier was 80% in office and perhaps 20% work from home, that has been completely reversed or more. What is interesting for students listening in, perhaps, is that this area is becoming a very important sub area of technology law practice, and it is at a cusp. So anyone reading up, anyone entering this, I'm sure will have an exciting time ahead. Once again, thank you for your question.
No, thank you. I think very well put. I think this is one of the issues which is existing. Uh, E-pharmaceutical, very controversial in news, because Delhi High Court had a view on it, and then we saw example of Arogya Setu, which was given by Akansha. Uh, FDI looks to be a great investment. Government wants to balance both sides of the coin, because it's a domestic protectionism as well as opening up the economy for more FDI in India, especially when we are preaching about ease of doing business. Uh, Aviral also spoke about how now consumers are protected, because you may have fake reviews for a product which has no value, which may not be of that particular category or something, but has been just highlighted, and therefore fake reviews, star marks, and other things which are now covered under the consumer law in 2020 rules, so that the government protects the consumer. Because as the e-commerce market and the business of doing e-commerce market, when consumers increase in taking products, we also want to secure consumers, because we don't want consumers to get into the trap where the product has no value, but you think it's a cheap product with cheap discount, and you buy it and it turns out to be a fake product. Number three, online brand management of the companies is also becoming very important. As Rodney said, on the General Motors side, you have all these apps coming up during the pandemic times. There's a reality check which is happening, and therefore the government is also putting regulations in place, because cybercrime and cyber fraud is also an issue in these sectors. All right. While talking about the information technology, cybercrime side of it, counterfeit products, etc., my next question is to Akansha. Uh, the liability of e-commerce platforms like Amazon, Flipkart, etc., in case of infringement of intellectual property rights has been widely contested issue. Uh, One of the examples which I can give you, in 2006, when Reliance got into this business initially, and I was there in the company, uh, the first controversial issue which came up was that a user wrote to us saying that the Nokia phone which has been delivered, at that time you had this big Nokia phone. He says this phone is from a gray market, which is of course China then. Uh, it's from a gray market. It's not a real product. And this was the first question which came up to us. Uh, I myself conducted in 2008 multiple raids. One of the raids which I led with the Mumbai Police, Mumbai Cybercrime Unit. We went to Jaipur. There was a person who was using fake credit cards of tourists who were visiting in Jaipur. And we caught that person. We brought him to Mumbai, booked him under the law. Uh, Intellectual property has been an issue where e-commerce platforms are saying we are just an intermediary and a platform. We are just bringing buyer and seller to business. We are just bringing convenience to your home. Why are you getting behind us on intellectual property rights? Let the buyer beware is of the law, which we also see in the Sale of Goods Act. In the absence of regulation against copycats and reverse engineers, plethora of counterfeit products are being sold on the e-commerce platforms, wherein these e-commerce entities often enjoy the benefit of Section 79 of the Information Technology Act to get exempted from intermediary liabilities in such cases. With the release of the Information Technology Intermediary Guidelines and Digital Media Ethics Code Rule 2020, will there be an imposition of new responsibility? Will there be an imposition of new responsibilities on the e-commerce entities? What can be the possible safeguard for aggrieved sellers in such cases? Akansha, thank you. Uh, so while we connect to e-commerce, the another issue, Abhishek, which usually comes up while we tie in with Akansha, the another issue which comes up with e-commerce is that e-commerce companies are processing large amount of data every day, from personal details of a consumer to their address, their personal debit card, credit card details, financial information, under the garb of a wide and elevated shopping experience or personalization to their visitors. There is a constant threat of data breach and abuse of privacy to the consumer. Despite the existing regulations on data privacy, there have been various cases of data breach by e-commerce companies. For instance, the data breach of Big Basket, which is a prominent e-mart, in October 2020. What measures can the regulatory bodies take to mitigate this situation? Because apart from the liability on intellectual property rights, there has been an issue of data privacy also, and it's been in existence, and we know it for sure. It's been in the market. What measures can the regulatory bodies take to mitigate the situation? Abhishek, thank you.
Sure. Thank you, Zamir. It's what is important also to highlight right at the beginning is that, and this is something which is recognized as basic principles of data protection and privacy the world over, is there is a distinction between personal data and sensitive personal data. So your personal data could be your name, your email address, your age, etc. And of course, there is a heightened level of protection that is afforded to the category as it is named sensitive personal data. Financial data largely falls in the basket of sensitive personal data. While we do not have a legislation in place, and we are all expecting that to, be debated in Parliament and or notified at the earliest. It was to be tabled in this budget session, but it's been pushed perhaps, and we may now only see it in the monsoon session. And once that comes into play, we will be a little, better equipped to answer certain aspects of the query that you raised to me in terms of what are the guidelines, whether they can be a little more robust, are they enough to handle what is currently the issue. But for the moment, what I can say is that there are two things that need to be sort of clarified. The first aspect is that a merchant, which is the e-commerce platform, is not permitted to store any financial identifier. The entities that are actually storing and or processing that are payment aggregators who are facilitating the transactions, and some bits of that information could be passing through the portals of the payment gateways. To address that, and mindful of the fact that there is no statute in place to govern and control the flow of sensitive personal data, the RBI itself has put into place various guidelines and regulations that govern this area, and specifically with regard to payment aggregators. There is a set of guidelines that were notified in 2018, then subsequently 2019 they were sort of modified. And what has been brought about is that payment aggregators have to mandatorily follow these guidelines. With regard to payment gateways, which relates more to the level of the technology that you need to put in place in order to ensure that these kind of cybersecurity breaches do not occur, those are not mandatory, they are only recommendatory, and it is open for the payment gateways to follow that. I mean, it's only axiomatic that in the event that a payment gateway does not follow the very basic level of threshold with regard to the technology and the protection that it offers, more and more there is likely to be less and less consumer traction and usage of that particular gateway. So it's only in their interest that they comply with those particular standards. So while it is recommendatory, but from a business standpoint, it is something which would be helpful for them to follow. So, and the important part again is that in the present set of clauses that prevail, that are there in the PDP draft bill, there is a requirement that the financial or the sensitive personal data that is being processed and needs to be retained here, and if it is being sent outside the cross border, then it has to be done with the consent of the principal. It is also required that if it is actually being sent outside within 24 hours, need to be brought back into the country. So those protections and the measures are already in place. In fact, the RBI has also notified a set of guidelines. If you remember, when we use sometimes a debit and a credit card, and it is in the usage of that pertains to a recurring payment that needs to be made every month or whatever, then there are guidelines put in place even to regulate that particular part of the transaction. So there is enough right now, in the absence of the PDP Act or any other data protection legislation, for the RBI to have stepped in by virtue of its rules and guidelines to govern this particular area. And we are not living in limbo or without any regulation at all. The specific example that you took of the big basket data breach, that's more in the domain of a data security, cybersecurity incident, where, and it's interesting that there are different ways of looking at it. I'm reasonably sure big basket would not have engineered this itself. It would have been the victim of an attack whereby such data would have been lost. Interestingly, whereas Big Basket is a victim, we look at it from the point of view of another lens to say that, look, are you liable for this sort of a breach? Whereas actually the entity which should be liable is the entity which has actually engineered the cybersecurity attack and taken away the material. So I think as the law evolves and cybersecurity is clearly, I mean, a breach of cybersecurity and that incident is clearly an actionable wrong, a criminal liabilities associated with it under the IT Act. If, however, Big Basket had not put into place the basic minimum standards that are recognizable in terms of the industry standards the world over under ISO, etc., then it could have been additionally liable for that breach. So I think with time and with the development of the law and the practice in this regard, we will find that there will be better roadmaps, clearer guidelines that will be put into place for companies such as Big Basket to be able to adhere to and steer clear of any liability that would attract towards it.
Any views on Section 79, which we asked to Akansha? I'll get back to you after I ask about consumer protection to Aviral now, because you may have an issue of intellectual property rights. There's a guideline of the government, Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2020, where there's a lot of reverse engineering, copycats, counterfeit products which are sold on e-commerce platform, wherein these e-commerce entities do enjoy the benefit of Section 79 of the IT Act to get exempted from intermediary liability in such cases. We've been seeing a lot of movements on that. I'll come back to you in this question if you can later on give us any guidelines. Aviral, while we are talking about consumers who buy these products from the e-commerce website, there might be a case of intellectual property rights. There might be a case of data privacy because a lot of information is taken for customer experience. And Abhishek also spoke about that the Big Basket data breach would have been, of course, being a security breach, which has happened in the organization. It would obviously not be activated by Big Basket, but some gap in the system, and the hackers would have taken advantage, as is been in the market. Now, in such situation where the consumer is exposed to a counterfeit product, intellectual property violations, the exemption is always claimed by the platform, saying that we are just a platform, buyer beware. Your data is with me, a lot of data is with the e-commerce company, and therefore they can channelize those products to you. What remedies does an end consumer have against e-commerce platform if a seller is engaging in selling counterfeit goods on such platform? What are the implications of an e-commerce entity potentially providing a marketplace for fake goods? What are the key metrics that an e-commerce entity should implement to mitigate against such exposure? Three broad questions, critical questions, because the consumer is otherwise exposed to e-commerce business.
Right, Zamir. Thank you for that. I'll just take this in two parts. One, of course, is the affected entity, who is the consumer, who has received a counterfeit good as such, and the other is perhaps the owner of the intellectual property, whose intellectual property has also been breached. Now, in any situation, either of these two entities may be the aggressor for an action, either against the seller or against the marketplace, or both. Now, the case against the seller, of course, we're not going to get into it. It's fairly straightforward. You have your actions under the Trademark Act, under Copyright Act, and under IPC. It gets interesting when we talk about the marketplace. You're absolutely right when you pose the question to Abhishek a short while back of Section 79 of the Information Technology Act and the role of intermediaries. I think what becomes important here to understand is what is the obligation on an intermediary to ensure that counterfeit goods are not on their platform, and B, when they do find out that there are counterfeit goods or there is a potential IP violation, what steps should they take? Now, for the first part, the law is pretty straightforward right now, at least. The law does not impute a standard higher than due diligence as encapsulated under Section 79 on intermediaries. As long as the marketplace can justify that they followed the various due diligence guidelines that are there under the intermediary rules and under the IT Act, they are in the clear. One very recent example, in fact, is a case was filed against Snapdeal in December of 2020, and Snapdeal's directors took it to the High Court under a 482, seeking to quash the complaint against them, saying that it's not really my fault. I conducted all my due diligence. I took necessary representations from the seller, told him you're not allowed to sell counterfeit goods, you're not allowed to sell certain types of, you're not allowed to do IP violation. And the court, the Karnataka High Court very clearly bought the argument, said that as long as you can justify compliance with Section 79, the problem lies with the seller. So the consumer has a dispute with the seller and not really with the marketplace. The complication, however, may come when we are talking about the owner of the intellectual property, not so much the consumer, but the owner. And here also, again, very interestingly, Delhi High Court in Christian Louboutin, there's a case which Christian Louboutin filed. I hope I'm pronouncing it right. Always get it wrong. But they filed a case against a website for selling their bags. The declaration on the website was it's 100% original Christian Louboutins. And they filed the case. The website comes about and says, listen, again, my policy is pretty clear. The declaration has been given by the seller, and the Delhi High Court was very clear that in order to implicate or hold the marketplace responsible, you need to show that the marketplace either aided, abetted, or conspired to for the intellectual property to be violated. And that is the standard that today we are imposing in a situation where a robust e-commerce policy is still not in place in India. We, as an investigative and regulatory force, Indian law errs on the side of putting a threshold for diligence, but thereafter nothing more. Very interestingly, in the national policy which I referred to earlier, there is a suggestion, I'm not sure how viable, of trademark owners being able to register themselves with these e-commerce platforms, which effectively results in any time when a seller is selling a product with that trademark, that e-commerce website has the obligation to inform the trademark owner. This would enable A, the trademark owner to know whenever if there is an infringement of their IP, and B, also act as a buffer for the e-commerce entity in terms of I have complied with my responsibility of even informing the trademark owner of a potential infringement. But to that extent, I think the law still stops at due diligence on counterfeit goods also.
Wow, very wonderfully put. I think you have put it from a perspective not only consumer but also the genuine companies which are really hurt by that practice. And therefore, we talk about regulations and putting checks and balances and governance in place. Because as this market increases, we don't want the problems to increase. We want the consumers to benefit, and we don't want to also promote the markets of counterfeits and affect the consumers who are the real buyers of the product, who have gone to your platform with a trust and faith that you will provide them a genuine product and not a counterfeit product. But yeah, I see an issue not only for the consumers, but also for those genuine companies whose product are now placed as a counterfeit on e-commerce, and what steps the e-commerce companies are doing. I think this is just checks and balance and governance mechanism which has to be put in place. And I think e-commerce companies are doing it well on that part. The governance has deeply increased because they are also accountable in terms of audit and responsibility under the law, not only in India, but if the company is a United States or a foreign company, they also have governance mechanism and accountability there. Abhishek, you want
Just
to add
adding,
anything?
yeah, sorry, for 79,
Yeah.
I think you did put that question also to me. The important point to note is, of course, 79 comes in as the extension of the principle of safe harbor, which was evolved under the Digital Millennium Copyright Act of 1998. And if it was to address a situation originally to copyright and then of course extended to other domains as well, where the platform will not have any knowledge and is not contributing to the infringement, but it is providing a facilitation, for lack of a better word, to the counterfeiting or the infringing activity. So the point is simple. If specifically in the digital domain, and of course we've moved on a lot between 98 and 2021 with regard to the deployment of technological and other tools to be able to assess at a very basic level as to what could potentially constitute counterfeit or infringing material and what may not. But at the end of the day, the entire point of Section 79 is that basic due diligence that you need to exercise, and what that basic due diligence is something in Kuwait, it will be dependent upon the facts and circumstances of each and every case. But once you have exercised that, you are no longer liable. Part of that basic due diligence also is that when you are informed that a particular product or let's say a work is infringing or counterfeit, then you need to, in terms of your policy, remove that. It's interesting that the Supreme Court in the Shreya Singhal case has said that the notification that you need to receive in terms of 79 before you act to remove is a notification that should come from a court or an authority, a statutory authority like a police officer or whatever. Whereas that's something which will unfortunately only increase the litigation, because then every time you need to get such an order, you need to go to court. However, thankfully, the businesses have reacted a little more practically, to my mind, where it is so apparent that there is this counterfeiting activity, and the owner of the IP is specifically saying that this is infringing or counterfeit, that will be removed, of course, with certain basic elements of due diligence even on the other side, to ensure, do you have a trademark registration? So your policy of takedown will provide for certain basic inputs to be provided before you can actually action that takedown. So I think those mechanisms that are there are implementation both of protection of intellectual property rights as well as of giving adequate protection to, let's say, an e-commerce player to say, look, I have exercised my due diligence. I do not need to do anything further. I'm not going to play the judge. I'm not going to say that there is deceptive similarity or this seems to be similar to the song that you claim to have ownership of. I'm not going to go down that path. So wherever there is complete clarity with regard to this situation, I will, in the exercise of my true due diligence, remove it, but not otherwise.
Right. So I think what e-commerce company said that even if you have a counterfeit product which is there, so the stand what Abhishek was trying to explain is the digital millennium law. Just to give you an idea, when this law came 20 years back, if you go to a website or an app, you find 3-4 things which is there as a legal terms. One is your terms and conditions. Okay. Most of the people, general public doesn't read that, but lawyers draft it and lawyers read it also. Number 2 is your privacy policy. What kind of information I will take from you and what is the purpose for which I'll use. I'll use it for marketing, etc. And then you have copyright notice, where if you click that section, it says that if you think that your material is available on this website, you can write to us with evidence and we'll pull it down. So today, as lawyers, when you see a notice of copyright infringement, what does the notice says? I call upon you to cease and desist. That cease and desist word came out of this digital millennium law, which was in United States. So anything on YouTube, suppose somebody has put your video and you want to remove, you write that to YouTube and YouTube then examines and removes that. All right. You can't then take YouTube to the court because that's a due diligence which has been exercised by YouTube. YouTube thought that in good faith this was put up. You have informed with evidence, they've removed, they've seized and desisted from doing it. All right. This was the option which was given. And most of the platforms, like today you're talking about e-commerce, which is Amazon, Flipkart, eBay, YouTube came in, etc. Facebook was there. Now, these are all the factors or the businesses of electronic which wanted to have that cease and desist option. So if you have done your basic due diligence, then you have the option to write to the particular company, e-commerce company, etc., to remove your product. And that's what the e-commerce company said, that we are just a platform. If you feel that something is wrong, let us know, we'll immediately get it removed. What Abhishek was trying to stress is that the companies have to exercise basic due diligence. You can't say every day that, yeah, I know today you complained about 4 products, tomorrow you complained about 8 products. Sorry, I was not aware that these are counterfeit, because then you are now getting into that business where you're not making a due diligence. You're just putting up products which are fake. Customers are buying in crores of rupees. And someday somebody brings to your notice, you are just walking out saying that, sorry, I was not aware about it. So basic due diligence and takedown mechanism, which has been provided on the app, is basically two things where the e-commerce platform is saying, I have done in good faith, I have removed it immediately, and therefore don't make me liable as an intermediary or a platform. All right. Because the other worry of the e-commerce platform today is that they have more than 1 crore products. And if everybody starts suing, this companies will have a hard day. Okay. This is the point which was conveyed by Abhishek. Going to my next question to Rodney. Rodney, we are seeing a mammoth trend in e-commerce which is happening. Amazon and Future Group entered into an agreement. Amazon took Future Group to Singapore International Arbitration Center for an arbitration on a non-compete clause where they could not enter into a contract with Reliance. Delhi High Court did not state that interim order passed by Singapore International Arbitration emergency arbitrator within 1 day or 2 days. But Delhi High Court remarked that there seems to be some issue on FDI, where Amazon would then go in appeal, because Amazon would say that I had taken a clearance of CCI, I had taken a clearance of the government on FDI policy. Today, after having spent money, if you tell me that there was a lapse in my FDI approval, then this will have repercussions, etc. We are seeing e-commerce companies going left, right, and center. Amazon has established a very big campus in Hyderabad, and therefore they are seeing a lot of businesses which are happening. Facebook has also started a marketplace where you can deal with it. What trends or patterns do you think were the most significant in the field of e-commerce in the past year, especially in light of the pandemic and subsequent the lockdown in India and elsewhere? Just give us a preview of that. Thank you, Rodney.
Right. Thanks, Zamir. One of the most important trends, of course, was security, because now you had to defend almost every home. It was like a war, because each one of us are working out of home. For all service providers, for the e-commerce marketplaces, security and therefore privacy. And in the context of this, in the context of trends, looking back and then looking forward, I think businesses with the highest standards will come out much stronger, and that is going to be a very important trend. And further to what Abhishek was saying, I agree with him. And about for example, reviews, there was one remark earlier. And if a business puts in place its own internal safeguards, for example, if I can only review a book on Amazon if I've bought it from Amazon. I cannot claim that that book is in my library or I picked it up from Connaught Place the other day. That means it's a verified purchase to begin with. So such practices, in addition, when a business goes beyond the letter of law and moves into the spirit, it's when it becomes, truly compliant. There apart from security, and of course a very powerful trend will be privacy, and I think that will be the trend for another year or two to come at least. By the time we settle into the uh, um personal data protection bill, which will become the act, we'll see the authority, we'll see the impact of these rules, we'll see engagement with social media outside pure e-commerce. There are going to be interesting developments with freedom of speech, with protests, with all of that. So I think, all in all, on each point, and I think that way, our panel is very well, because we've focused on about 5 or 6, and there are more amazing trends, which I'm sure will be very important, not just for 2021, but going ahead in the next couple of years as well.
Yeah, I think we had complete variety of the discussions we had on e-commerce. Substantial issue, government is also looking at it, whether governance is required internally or there is a regulation requirement. Issues are really coming up. If you see the 360-degree of the discussion before we go to the question rounds, which we have got, uh, we started with e-pharmacies. We took you to the liability of e-commerce as a platform under Section 79 of the IT Act, where the e-commerce platform is saying, I'm just a platform or an intermediary. We spoke about the FDI policy in e-commerce, where you're a marketplace model or an inventory-based model, where government says if you're one of them, then FDI is permitted, one of them if FDI is not permitted. We spoke about a lot of personal privacy data issues. A lot of personal data of yours is with the e-commerce companies. We saw a case in point of Big Basket having a data breach, which has happened. We also saw from a consumer angle that, where there are fake reviews, government has now come out with rules in 2020, consumer protection e-commerce rules, which then now protect a consumer, which can go against the e-commerce companies. We also saw the consequences of having counterfeit goods on your platform. We saw there are cases of trademark infringement and e-commerce goods on e-commerce websites, cyber fraud, impersonation, online brand abuse, which is happening, and the trends which we are seeing. These are the real issues which e-commerce companies are facing it. They are addressing with the existing mechanisms. They are increasing their governance. They are increasing their due diligence. Government is also looking at it and regulating it by passing various rules, regulations, etc. As we saw in the case of consumers, where fake reviews were given for products. Government also came out with IT rules, information technology rules, where the platform has to be responsible in some context. Government also is looking at the counterfeit products which are sold on e-commerce platform, and therefore the companies are doing their basic due diligence, governance, and compliance mechanism. Government is addressing by way of regulations where it is required. Government is also not going into over governance, because at the end of the day, we also need to look from a perspective of ease of investment, but also take care of the domestic business as well as have foreign direct investment coming into India. I think it's a really 360-degree of view which has been taken on the e-commerce platforms by my learned panelists. I will just go to the questions. We have got a lot of questions. We have time limit of about 5-10 minutes more. I'll try to address as much as questions from my panelists.
Zamir, just one point before you go to the question, which I
Yes.
wanted to highlight.
Yes, please.
And it's an
Yes,
important
please.
thing because
Yes. Yes.
it is a recent development in the space of e-commerce,
Yes.
which I just wanted to highlight, specifically in the case of social commerce. We
Yes,
have
please.
moved to a situation where it's not just a business in the form of an e-commerce model where there is, whether it's inventory, marketplace, whatever, and there is sourcing of goods from known sellers, etc., and there's a sale of that. The reason to make that purchasing decision on an e-commerce platform is typically of the buyer alone, largely uninfluenced by what they are looking at, what they wish to buy, etc. Yes, we do see some consumer reviews, either of the product or of the seller, and then we make our decision accordingly. In the case of social commerce, however, we moved to a situation where we are using technology, we're using things like WhatsApp groups and the others, and where an individual who's either a relative friend or otherwise, or maybe even just a social media influencer, is actually influencing the purchasing decision of someone sitting at home to promote and propagate a product and getting a commission in return, right? This is akin to, direct selling, direct marketing that was available in the brick and mortar world. But you had an identified person. That person would again perhaps be a friend, would be someone that you know, or you may not know, but they were looking at, formation of those chains and those discounts and then the commission that are coming from that. Here, the trust factor that is inherent in the relationship is, in my humble submission, being exploited to a certain extent and perhaps in certain cases even abused to be able to push products to unsuspecting customers. And that really causes a huge body of concern, specifically with regard to where this is headed. And that's where the issues of counterfeit goods, that is where the issues of lack of consumer protection is at its heightened worst. So that's something which I think is extremely important for the regulators and the government to look at, and to perhaps bring in similar levels of regulation in terms of identifying where you're sourcing the product from, the due diligence aspect. All those aspects need to come, legal metrology, they need to be enforced even in the social commerce domain, which are already applicable to e-commerce.
Good discussion. In fact, that is why WhatsApp has a business version also. And what you said about social marketing. In fact, one other example apart from WhatsApp is Pinterest. If you have heard about Pinterest, so we have Facebook, etc., also starting marketplace. But Pinterest earlier was to only save information about the product or about your entities if you want. The original line of the business is Pinterest is an American image sharing and social media service designed to enable saving and discovery of information. Presently, Pinterest has completely turned into the area what Abhishek was talking about, and that is garnering, which is social commerce. And if you see the shares of Pinterest 1 year back was about $15, and because it has now being into social commerce place where people are selling product, the commerce is influencing it, the value of the shares is now $71, which is 4,900 rupees for one share of Pinterest. That's how it is making a difference to the life. So that's about social commerce, was Abhishek was putting about, where you also have now markets opened up on WhatsApp, Pinterest, etc. This is how businesses are going. So e-commerce, social commerce is a growing field. We've highlighted the issues. We've highlighted how we can address that. The government is also addressing step by step so that there is no over governance, while the e-commerce companies themselves are also trying to have good governance and compliance in place so that they are also not caught on the wrong foot. With that, I will start my first question. Any panelist can answer it. We'll just take 2 or 3 questions. We've got a lot of questions. We can offline answer that. Are these e-commerce platform or markets in violation of the competition law on monopoly, etc., and antitrust policies by way of creating an asymmetry of information among the consumers by way of constant personalized advertisements along with hefty discount and sales? What impact is being caused on the consumer purchasing pattern and the traditional vendor? Anyone?
If I may, I just have a couple of points to add on that before the other panelists come in. It's a very interesting question. The competition law paradigm in India right now, unfortunately, is extremely price centrist. They don't treat data as a price sensitive aspect of any competition law analysis. Prime here is Facebook's investment in Geo back in 2018-19, where the entire investment was for data, yet still the Competition Commission did not value data on a price scale to see whether that would affect the price of the transaction, and therefore there was no input. The reason why I highlight this is antitrust policy in India does not look at leveraging of data as, at least currently, there are law commission reports on this, but currently as the law stands, they don't look at leveraging of data as a price sensitive aspect of any transaction. That being the case, any personalized advertisement which has resulted in leveraging of data to market a product may not be hit by this policy. The counter to this, of course, is the definition of what is an unfair trade practice, like I touched upon under the Consumer Protection Act, has been clarified. And that effectively deals with only when you are posting misleading information. That's, if you look at the 8-10 odd subsections on defining unfair trade practice, it's veering towards when you're giving out wrong information. So even if you're offering a discount, it's not a problem. It's only a problem if you offer it, but finally don't go through with giving that discount. So from a competition law perspective, at least in my view, the e-commerce field is still not very well regulated because of lack of appreciation that data is valuable.
Oh, okay. So
Just
you are
coming
saying
in
that,
there,
sorry.
no, please,
So you are saying that, these deals which are happening in the e-commerce field also, it was Walmart and Flipkart also, has more also relation to the market, of course, because India is a good market, is a big market, and most importantly, data of that market, which has not been factored into while evaluating the deal with the regulators, is one of the point you're putting across, and that needs to be captured or taken into consideration while making a decision. Abhishek, on the same point, just to add the second question where you can then holistically answer, despite the laws, allegation of unfair practices by foreign e-commerce companies continue to crop up, including deep discounting, predatory pricing, preferential treatment to select sellers, and other practices that affect small retailers. What, in your opinion, can be the way forward? So, plus that you can address it. Yes, Abhishek.
Yeah, no, in fact, I was going to actually address that proposition itself. So I think a part of this aspect of the prohibition of FDI in the inventory model addresses this to a certain extent. Selling of white label products, having control over the production entity, either in terms of a shareholding control or in terms of selling more than 25% of the inventory. All those aspects have been brought in to the policy and the regulatory regime actually to address those very issues. We do have matters pending before the courts as well as the CCI with regard to the allegations of anti-competitive behavior on predatory pricing and deep discounting. And that's something I guess we will soon see as to which way the law sort of
Okay. So, Abhishek, while we touch base with you, I mean, I have also got a question on the press note of the government, where the press note was saying that the services may be provided to vendors on an e-commerce marketplace only at arm's length. So when the government came out with two models saying that inventory model, marketplace model, FDI permitted, not permitted, the FDI which was not permitted in that particular model uh, was from a perspective that these companies don't get along and have a backdoor entry with the sellers and therefore dominate the inventory market also. Uh, Now, coming from that perspective, it was only to be meant for an arm's length. Marketplace proposal was only meant to be from an arm's length point of view. It has to be fair and non-discriminatory manner by marketplace entities. Other entities in which marketplace entity has direct or indirect equity participation or common control However, certain questions have been really raised in relation to this requirement, including cases where marketplace entity has minority participation in another company without control of its board of directors, etc. How can fairness requirement be enforced in respect of these entities when marketplace entity does have direct or indirect control? Do you feel that we should now have a regulation pinpointing that, or these are practices which should be indirectly allowed as a ease of doing business, or it's time to put a regulation in place and saying that, when we permit FDI, it is with certain terms and conditions, and those conditions have to be sacrosanctly followed in letter and spirit as well. What's your view on that, Aviran?
I'll let Abhishek and Rodney respond to that first, and then from the perspective of the FDI press note, I'll add thereafter as required.
Okay.
So
Yes,
I
Abhishek.
think the extent guidelines that are already there and the mechanism for enforcing them, to my mind, is adequate. We have had a consolidated that the FDI policy in 2017, then thereafter in 2018 a revision, and now we have a consolidated policy circulated in 2020. So, to my mind, the distinction that has been made between the marketplace and the inventory model and the existing parameters for how you measure one against the other are adequate. It's not to say that any particular law or regulation will not be abused. In the event that it is, there are enforcement mechanisms available. There is, in the event that there is a violation of the FDI policy, then the law will take its course. That you can potentially take action either in a court of law. There could be implications under the FEMA, and those aspects can always come in. And I think those are deterrent enough for
Absolutely.
entities to not violate the law under the garb or guise of structuring. That's
Like was
my
pointed
response.
out by Delhi High Court also in the case of
Correct.
Future Group and Amazon, where it says
Absolutely.
that it looks to be a bigger picture now when Amazon has come to the court and has to be examined.
Correct.
Okay. Okay. Aviral, anything? Rodney,
No,
anything
no,
you want to
I
add?
completely agree with that because uh, our enforcement structure is pretty robust. While people, of course, I know and have complaints against the investigative and enforcement mechanism in India, it's pretty robust and uncomplicated to the extent that if required, they can go down the route of rectifying any breach of either the FDI policy or any other investment structuring that is done.
Okay. Yeah. So I think from a broader perspective, we have taken up all the issues of e-commerce which are happening. We started with e-med because e-medicines because that was growing up. We came down to counterfeit, intellectual property rights, FDI, government trying to balance between domestic protectionism as well as securing FDI. Uh, we spoke on the aspect where how consumers can now be protected because in e-commerce business, consumers are increasing. They are making big purchases from e-commerce websites. And therefore need to have some basic protection on the kind of products they are buying, the authenticity of those products. Those products should not be fake, etc. E-commerce companies have been diligently addressing this from a governance and compliance point of view. They're making their due diligence while uploading products. They're keeping consumers in mind because they're consumer focused companies. This can earn a bad reputation and therefore they're conscious about it. Government is step by step coming out with a lot of regulations where they feel that things have to be fixed up, responsibility has to be fixed up, liabilities have to be fixed up, either with the company or it has to protect the consumer who's now making most of his purchases from these e-commerce companies like Amazon, Flipkart, etc. Uh, there have been a lot of investments in India which have happened. Geo Facebook collaborations have happened. People are looking out at payment gateways. Amazon Future Group has also entered into an agreement that particular agreement had a non-compete clause having the name of Reliance, which became a controversy in the Delhi High Court. It's before arbitration because Amazon and Reliance feel that e-commerce is a great market in India. We had Walmart collaboration with Flipkart, which happened. which looks to be a field that e-commerce is now bigger and very influential, and therefore keeping checks and balances in favor of the industry as well as the consumers. The government is moving towards ease of business, but companies are also required to ensure due diligence and compliances. This is all what we had. I had the privilege of having a great panel with me. Good questions also came up from the audiences. We've issued most of the issues which are coming up on the e-commerce side. I am once again thankful to Abhishek Malhotra, founder and managing partner, TMT Law. Great views. Akansha Kaul, advocate, Supreme Court of India. A lot of good views coming on various aspects of e-commerce. Aviral Sai, principal associate, Cyril Amarchand Mangaldas, good views on the consumer side of it. Rodney Ryder, Mr. Rodney Ryder, partner, Scriboard, advocates and legal consultants, mostly on the counterfeit and online brand management the company should have. I think overall e-commerce is a very influential market. There are legal issues which are being addressed. There are regulations which are being brought by the government. But so far, the market has been growing, and therefore, even the FDI investment looks to be bigger in the market. Let's see how it goes in the future. While we have given answers to many of the issues, we will see those issues being addressed by the government, law, or the courts in future as they come up before them. I want to once again thank all my speakers. I want to thank Dr. Anand. I want to thank Rajiv Gandhi National Law University, Financial and Mangaltide team, Lex Witness, Society for Corporate Legal Experts, and everyone who spent a lot of efforts. I want to especially thank all the audiences also for patiently listening to us.
Thanks, Amir, for being such a great moderator and putting such apt questions and enabling us to respond to those. It's a great role that the moderator plays to fashion discussion in such a way that output comes out from the speakers as well. So thank you so much for that, and thank you once again to RGNUL as well as Lex Witness and Society for Corporate Legal Experts, as well as to my panelists. Thanks a lot.
Thank you so much, everyone. Thanks, Samir, RGNUL, everyone. Abhishek, great to see you after a long, long time. I guess.
Likewise.
Thank you, everyone. Thank you, Zamir. It was a great discussion and hope to be back soon.
A very big thanks to all our speakers. I think it has truly been a very intriguing session, and I hope that all our attendees found the discussion very helpful. Please note that a recording of the session will be available on the YouTube channel of RFMLR and the Society for Corporate Legal Experts. And once again, thank you all for attending.
Thanks to all the speakers for being a part of this expert panel discussion. And thank you, RGNUL, RFMLR for organizing it with us. And thanks to the team Lex Witness to co-host the event with us. Thank you so much.